Hello, I'm Natalia Angelini.
And I'm Nick Esterbauer.
Welcome to Holland Estates. You're listening and watching episode number 546. And we are going to be podcasting today about attorneyship planning, right? Power of attorney documentation.
That's right. So when it comes to incapacity planning, really what you're dealing with are different planning options that present themselves to clients and to the lawyers assisting them when you're preparing powers of attorney for property, whether a continuing power of attorney for property or a standard power of attorney for property, as well as powers of attorney for personal care.
Right. And as litigators, we see what goes wrong on the other side of things. And so we thought we would touch on a couple of the core areas where problems can arise and try to address ways to mitigate that. And I think one of the first ones we were focusing in on, which happens a lot, is when you've got attorneys that cannot work together. And this is typically, we find this often in the sibling scenario. You've got multiple siblings, or potentially you've got a second spouse and children from a prior relationship, which is less common, but these kinds of mixes can happen and can often lead to some disagreements.
Right. So we often see that an incapacity planning client has chosen to appoint all of their children, all sorts of people out of a sense of duty, knowing full well that these people don't get along and they probably will struggle to cooperate if they're required to make important decisions on your behalf while you're incapable.
Right, and some of the consequences that we deal with or that can arise are you've got your affairs aren't being managed in a coordinated way. It can lead to court applications where one attorney perhaps is seeking directions at the court because an issue has arisen with him or her and the other co-attorneys.
And in more extreme cases, we'll see applications for the removal of an attorney or guardianship application. That can become highly contentious litigation that can continue long after the incapable person has died.
Yeah, it can be costly and time-consuming, right? And potentially, I mean, most importantly, really damaging, fatally damaging to the familiar relationships. And there's a case, Vanier, that I think it's been podcasted on before, but we just wanted to briefly touch upon it because it is a situation where attorneys were at odds with one another.
Exactly. So that's a decision from last year. It was before the Ontario Court of Appeal, and it saw a dispute between co-attorneys. The grantor had attempted to fix the problem by executing a new power of attorney document, appointing just one of the co-attorneys, thinking that that person on their own would be fine acting. And then there were allegations that the new power of attorney was invalid on the basis of mental incapacity or undue influence by the new sole attorney.
Right. And I think it was one of the appellate judges, the Justice Epstein, who referenced the devastating impact on the finances, and financially and in respect of the relationships as a result.
Exactly.
And so some of the ways that we thought might help avoid that kind of a scenario is when you are advising your client who is getting a power of attorney document prepared, that you ask a bunch of probing questions, speaking to the reasons why they may want to appoint multiple people, and just getting the client to think about why they're doing it, and to think about the relationships and whether there's going to be an issue there amongst them, and if there is, talk about alternative options. For instance, you may want a professional attorney, along with a family member. You may want one person on their own. You may encourage a client to do that if the optics seem appropriate for that situation.
Or the rationale of why the client is choosing to appoint either more than one person. Why aren't you just appointing one of these people? And if you're appointing more than one, is it for practical reasons? Is it because you don't trust one of them? I mean, that could be a red flag for drafting solicitors.
Right, and I think it's hard because these are often like small retainers, right? People want their powers of attorney done for $100. And so not a lot of time is typically spent having these discussions in any kind of, in an extensive way. So it's just a reminder to all of us to, even though it is, a modest retainer, to spend that extra time because it will really benefit the client down the road.
I always find it surprising, Natalia, that incapacity planning is often sort of an afterthought of the estate planning process, but these are the plans that actually impact the person while they're still alive. I mean, for me, that seems something that's worth considering fully and making sure the client's fully informed and makes decisions that are going to help with the streamlining of the management of their affairs.
Exactly. And for the client to appreciate all of the what's really involved, especially with respect to, well, both, but particularly with respect to finances, all of the powers that your attorney has, unless you've got certain limiting language within your document itself.
Exactly. So the Substitute Decisions Act provides for very broad authority of attorneys for property and attorneys for personal care, and without restrictions in the document itself, they're able to exercise all those powers. So for example, for an attorney for property, you can do anything with that person's property that they could have done while capable except to make a will.
Yeah. So your client may want, for instance, restrictions in terms of gifting or restrictions in terms of dealing with large assets like their house. So, they're not necessarily going to think about that unless you raise the issue and ask those questions and have that fulsome discussion. So those are some of the things we thought about. And I think the second scenario that we're considering where there issues can arise is where the plan created isn't consistent with the client's intentions.
Right, and sometimes issues relating to that might not come up while people are acting under this power of attorney, or they might be more obvious. So for example, the Substitute Decisions Act outlines all these default provisions that apply unless the document states otherwise. If a client doesn't understand that an attorney will automatically be entitled to compensation unless they specify otherwise, that might be a problem. And it may deplete the assets available to that person if there's some payment of compensation in a way that they didn't intend.
Right. Their assets are going to definitely impact, or would likely impact what each individual person would like to have happen in terms of compensation. And some people, if they're not getting the advice, may think, well, here's my power of attorney document. It doesn't speak to compensation, so they may not even realize that the attorney's got any entitlement to make that kind of a claim.
So I know another point, we were just talking about the ability of co-attorneys to act together. So unless the power of attorney document states otherwise, if you're appointing multiple attorneys, they need to act jointly, which means that they need to make all decisions together. They don't have any unilateral decision-making authority.
Right, and that's another thing to consider. Maybe your client wants that in terms of all dealings, or maybe only some dealings, especially depending on who the co-attorneys are. There may be, if they've got concerns, they may want, 2 or 3 heads put together to make certain really important decisions.
Exactly.
Like I touched on before. Yeah.
Sometimes in the documents we'll see a majority clause saying that decisions may be made by any majority of the attorneys. Sometimes it will specify that one attorney needs to be included in that group, such as a spouse, in order to, especially for big decisions like the sale of a family home.
Right. Yeah, we see those kinds of clauses fairly often. So these are sort of the two main scenarios where we see issues as potentially arising and things to consider to discuss with your clients. And unless you've got any further comments, I think that brings us to the end of our podcast.
Yep, I just think that powers of attorney are such simple documents, or they can be anyway, and that's fine as long as you're incorporating your client's wishes in there and they understand what it means and they're happy with that. That's fine, but you just need to spend the time considering these issues.
Well said, Nick. So I think that concludes our podcast, and until next time, I want to thank you for listening and for watching. I'm Natalia Angelini.
And I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hullandhull.com or leave a comment on our blog.